The case we have is People versus Mead, and I would call the appellant. There will be 15 minutes of argument for each side.
Good morning, Justices of the Court. Chief Justice Michael Ferrone, appearing on behalf of Defendant Appellant Larry Mead. This Court...
Pull the microphone to you closer, please.
This Court and the United States Supreme Court have often instructed that reasonableness is the touchstone of any Fourth Amendment analysis. And the law is well settled that any police search undertaken without judicial involvement, without a warrant, is per se unreasonable unless it falls within a well-delineated exception to the warrant requirement. We believe this case could affect many people beyond Mr. Mead. Who among us could not find ourselves in the place of Mr. Mead? He accepted a ride from someone. He entered the vehicle with a backpack. Who among us has not done that? Entered a vehicle, perhaps of a friend or an acquaintance, brought a backpack, attaché case, purse into the vehicle with us. In this instance, the police became involved merely because of a bad plate on the driver's car. None of us checked the plates on a car when we accept a ride. The car was stopped. The police have tremendous power at that point to bring the people outside of the vehicle, begin questioning them, and essentially start a police investigation. Now, the prosecution might respond that none of us are going to find ourselves in the place of Mr. Mead because Mr. Mead had 4 grams of methamphetamine in his backpack. Hopefully, not too many people in the room will be found with carry methamphetamine. But the police did not know that when they stopped the car and when they focused on the backpack and really decided, out of curiosity, mere curiosity, that they were going to get into that backpack. The officer, Burkhardt, in this case, candidly testified. He had no probable cause to believe any crime was occurring beyond the driving without a license on the part of the driver. He had no reasonable articulable suspicion that there was a weapon in the car. He was very honest about that. So, where does this bring us? We believe that this court's order, respectfully, in LaBelle, was wrongly decided. It is an order. It wasn't an opinion. It would be my assumption that less time is going to be spent on an order than an opinion. We just simply respectfully believe that the LaBelle opinion is incorrect in 3 significant respects, and that the Court of Appeals opinion in LaBelle was right on everything and should have been affirmed. An opinion written by Judge Sawyer and joined by Justice Wilder, then Judge Wilder, on the Court of Appeals. We believe that this court should actually take the Mead opinion from the Court of Appeals. If you were to change the name of the defendant, it would read exactly as it should. How did the LaBelle opinion get things right and this court's order in LaBelle get things wrong? Well, first, probably the most significant, and this is actually why the Court of Appeals ruled against the appellant. If we look at the Court of Appeals opinion in this case, our position is it's a wonderful opinion. We agree with 90% of it. It's well written, thoughtful, but they concluded that because of the Raucus decision and because of LaBelle's interpretation of the United States Supreme Court decision in Raucus, they had to find that Mr. Mead had no standing. Well, if we look at the Raucus decision, it does not hold that there's no such, that passenger standing does not exist in the law. It's been interpreted over the years. It's not even a new case. It goes all the way back to the late 70s. It's been interpreted, misinterpreted, not simply by the Michigan Supreme Court, by courts throughout the country to mean that we're not going to recognize passenger standing in the police search of a vehicle. And we know that. It's kind of at first glance, it's kind of an outrageous, or maybe that's too strong a word, but outlandish claim for the defense to make in this case that all these years, different courts, many courts, have misinterpreted Raucus. But fortunately, 2 weeks, sometimes the fate strikes, and 2 weeks before, I believe it was about 2 weeks, before we filed our brief in this matter, the United States Supreme Court issued a decision in a case called, and this is discussed in a brief, United States v. Byrd. And in Byrd, which did not involve passenger standing, but the court nonetheless turned to Raucus because the Attorney General in that case, not from Michigan, different state, had argued that Raucus apparently denies passenger standing. In Byrd, there's probably an analogy to a passenger because the defendant in Byrd was it was a rental car and he wasn't on the lease. So presumably that's how it arose. And the United States Supreme Court writes, quote, there in Raucus, the court disclaimed any intent to hold that passengers cannot have an expectation of privacy in automobiles, but found that passengers there had not claimed any legitimate expectation of privacy in the area of the car which were searched. And that's true. If we turn to Raucus, the defendants told the court that the evidence they were trying to suppress, I believe it was a weapon and related evidence to a robbery, wasn't theirs and that they didn't know about it. And the United States Supreme Court reasonably held that, look, you can't have a reasonable expectation of privacy in property that you are saying is not yours. In this case, Mr. Mead has from the beginning accepted that the backpack was his. When Officer Burkhardt approached the car, he sees Mead with his arms around the backpack. When Officer Burkhardt gets into the backpack, discovers the methamphetamine, Mr. Mead immediately announces, actually before the officer said it was methamphetamine, Mr. Mead announces it was methamphetamine. At his trial, which wasn't much of a trial, he told the jury that the backpack was his. And he argued, which you, under the law can't argue, that the jury should rule in his favor because of the bad search.
Mr. Ferrone, why shouldn't this court apply the good faith exception to the exclusionary rule in this case? Given that the trial court judge and 3 Court of Appeals judges believe that the search was lawful under LaBelle, why wouldn't a reasonable police officer also believe that the search was lawful under LaBelle, especially when the standard state Michigan police manual cites LaBelle favorably?
Well, that's a good argument. I understand. That's not an issue we were asked to brief, but I understand that is the argument of opposing counsel. And here's why. The LaBelle order, it's an order. The law, the applicable law is Raucus, and other cases we discussed in a brief, Gimeno, Rodriguez. And those are not new cases. In particular, Rodriguez v. Illinois and the principal case, which brings Raucus. So, given that law set forth in Raucus, given the law in Gimeno, which says that consent to search a vehicle does not necessarily include every container within the vehicle, the officer could not have been acting in good faith. And I use the expression good faith in a legal meaning. I'm not accusing the officer of, anything outrageous, lying, this sort of thing. Actually, he was very candid at the suppression hearing.
But more technically, does that mean is your argument that LaBelle was not binding appellate precedent because of Raucus and Gimeno and Rodriguez?
It's actually not very clear. We've always assumed that it was because this court has issued opinions which state that an order, if it sets forth its reasonings in some detail, is binding precedent. So we have not argued otherwise. We think that would have been a losing argument.
So then it's your argument that it wouldn't be reasonable for an officer to have relied on LaBelle given the Supreme Court precedent? Is that correct?
Yeah. Well, our position is it would not have been reasonable for the officer or the person who wrote the manual or the department to use this court's order in LaBelle in disregard the longstanding precedent in Raucus, Rodriguez, and Gimeno. It's sometimes the law conflicts, but the person who wrote the manual would have known that even the Supreme Courts of every state have to follow the law of the Supreme Court of the United States. These aren't circuit court opinions, district court opinions. We're all required to follow them.
But isn't it possible that someone acting in good faith might think, all right, so the Michigan Supreme Court did something that no other court seems to have done, but in LaBelle it decided to parse consent searches in cars differently than consent searches in other places. I mean, is that one fair reading of LaBelle that would make it binding precedent upon which an officer acting in good faith could rely?
Oh, well, I can't argue that under the LaBelle order, what the officer did would be a valid search, and that's why we're arguing the order is just wrong. However, there's the fact there's other precedent out there which takes precedent over the LaBelle order, but also let's consider what the officer did. He stops the car. He knows almost immediately as he approaches it that this backpack belongs to Mr. Mead. He ignores Mr. Mead. There's really nothing on the record indicating, he certainly never asked Mr. Mead if he could search the backpack. There's not much on the record of any action between the officer and Mead. He instead focuses on the driver. At that point, all he has is a bad plate. This isn't, that's I'm not sure if that's even a misdemeanor. I get involved in many cases like that. I think it's just a civil infraction. Asks her to get out of the car, or is out of the car. Police have tremendous power at that point. No one's going to refuse to get out of the car. She exits the car, asks for permission to search her, searches her, finds nothing. Same with Mead, finds nothing. He knew the backpack didn't belong to Miss Taylor, the driver, and yet all he had in his mind to justify the search of the backpack was her consent to search the car. And we know under Gimeno that's not necessarily sufficient. Gimeno's not a new case either. It was the law when the search occurred. And we know that the officer, from the audio camera video inside the car, and his partner had fixed on that backpack and were determined to get inside it. We know from his own testimony he had no reasonable cause to believe there's going to be any evidence of a crime inside that backpack. We know from his own testimony that he wasn't concerned about a weapon being in the backpack. Mr. Mead is 15 feet away. So, in some sense, where is the good faith? Even under LaBelle, where is the good faith here? He did everything possible to achieve his goal out of mere curiosity. That's all he had, was curiosity about the backpack. There were some admissions made that these people had maybe, quote-unquote, used drugs in the past. We've cited the case law in our brief. Two things on that. Number one, he didn't, they had already decided, the police had already decided to get into that backpack before those conversations were made. I'm not focusing on that too much because I think as most or all areas of the Fourth Amendment, we look at things objectively, not the subjective intent of the officer. But it is the fact that it's part of the picture that he was intent on getting into that backpack.
So is your answer, though, that the good faith exception doesn't apply because the officer should have known that LaBelle does not apply under these circumstances?
Well, the individual who wrote the police manual should have known, yes. I wouldn't say necessarily the officer. I don't know that he has any legal training. I can't. Actually, I think most people throughout the country who are non-attorneys, most police officers would know that a United States Supreme Court decision takes precedence over an order from a Supreme Court.
So while the Michigan Court of Appeals has to follow our orders, the person writing the manual does not?
Well, I wouldn't indicate. Of course, they have to follow your orders, but that was an order after all, in Mr. LaBelle's case, and it's, yes, but they're also required to follow the decisions of the United States Supreme Court, and we think here we actually believe the Court of Appeals sort of indicates this. There's not really any ambiguity here. Raucus does not do away with passenger standing. Gimeno is very clear. Simply because you have consent to search the car does not give the officer permission to search or necessarily give them permission to search
I see where you're going with this. You indicated we didn't ask for briefing on this. We didn't specifically ask for briefing on good faith exception, but the order that granted this argument asked whether there are any other grounds upon which the search may be justified or the evidence may be deemed admissible. Wouldn't it seem obvious that would include the good faith exception?
Yeah, I think that's a fair point. And we do address the good faith exception in our reply brief. I can't deny that. Probably when I first read the court's opinion, I did not consider we were going to argue a good faith argument. However, opposing counsel briefed it. I responded to it, and I totally agree with what you just said. Looking at the order,
do we know enough from the record to make a determination on the good faith exception?
I actually think the record as it exists is clear. The officers testified. No belief in probable cause, no finding of probable cause that a crime occurred. No reasonable articulation of a belief that a weapon was in the car. I actually think the existing record is sufficient to deny applying the good faith exception.
Counsel, you've several times argued in response to questions from Justice McCormick and Justice Zara that the search here breached the Constitution in several respects. Isn't the problem with that response that the good faith rule is never invoked, it's never triggered, unless there's been some constitutional breach, some constitutional violation? So, assuming there's been a constitutional violation, what's wrong with the idea that the officer nonetheless had good faith in what he did in his undertaking?
I do not disagree with that at all. Clearly, the fact, there was a constitutional violation, that is when the good faith exception is invoked and applied. I do not disagree with that. And pretty much that's my argument on the good faith exception. And I guess I go back to where I started out. This case, the good faith exception is going to impact Mr. Mead. It will determine whether there's a retrial or not. But the issues here are far beyond, the impact actually could be far beyond Mr. Mead. So I would ask that the good faith exception not be applied. I don't believe it fits into the Supreme Court decisions. We could go through those. However, I agree that the fact of a constitutional violation does not mean that the prosecutor can't invoke the good faith exception. In fact, that's when it is invoked.
Mr. Ferrone, at the time of the stop here, LaBelle was the law in Michigan. And given that fact that the law was that there's no standing for passengers, why wouldn't the good faith exception apply when the officer had no reason to believe there was an objective reason for the passenger to object to his search?
Well, those are valid arguments. I agree with not arguments, but the questions and the implications of them. I think they're all reasonable. My position is that's true. LaBelle was an order, went into the details. It applied to Michigan. Court of Appeals had to follow it. That's always been my assumption from the beginning of the case, going all the way back to the Circuit Court. Court of Appeals had to follow this LaBelle order, unless we could distinguish it somehow, which is a different topic. However, the only response I have is that in the background are United States Supreme Court decisions, Rackus, Jimeno, Rodriguez, which the officer also had to follow.
Let me tease that out a little bit. Is there a different standard for police departments, the state police, officers on the street, in regard to how you would look at what's good faith?
No, not that I know of. I'm not aware of any cases that distinguishes that. And as far as I'm aware, the same would apply to whoever drafted the manual. I don't know of any changing standard.
So if the state police manual says one thing, is the officer charged with knowing something different?
No, I'm not here to argue that this officer had any awareness of Rodriguez or Rackus.
The point is, how does an officer know that the manual might be different than Supreme Court precedent?
Right. Yeah, that's a fair point. I am not focusing on the officer so much as the person who drafted the manual. I think that is where the good faith argument fails.
Does the record reflect? Does the record reflect whether the officer was aware of the manual?
I'm not aware of that. I can't state with certainty that he didn't. It's possible it came up, arose as a topic. I don't have any memory of that.
Does it matter, or should it matter to us, whether the fact that there's Sixth Circuit precedent that would go in the opposite direction of our order in LaBelle? Does that factor into the analysis?
It's persuasive authority. The court's not required to follow. This court is not required to follow it or apply it.
That's true, but is law enforcement required to follow that authority?
Yes. Whoever drafted that police manual was obligated to, which is to say the police department, to follow the Supreme Court decisions. And in their case, yes, also they should take into account decisions from the Sixth Circuit. I can't cite a case in which holds that the police are required, in the state of Michigan, state police or local police are required to follow Sixth Circuit precedent. But it does interpret Rackus and Rodriguez and Jimeno. Those are older cases, but they've been courts have been applying them ever since. So I would answer yes, they should have been taken into account by whoever drafted the manual.
But that's different with respect to the officer, who, as far as the officer knows, the manual is correct.
Based on the record that exists, I can't argue that the officer had any reason to believe that the manual could not be relied upon.
If the officer even knew about the manual.
If he knew about it, correct, yes.
Are there any further questions? Okay, thank you, Mr.
Thank you.
Ferrone. Thank you very much. Mr. Schroetenboer?
May it please the Court, Jerry Schroetenboer, Jackson County Assistant Prosecutor. Well, let's start with good faith. People v. Kroll, 1993, an opinion of this Court flat out says, our orders are binding. You don't get to just ignore them. Now, what do we have in this case? Defense counsel at the trial level said, yes, LaBelle applies. It controls. Circuit Court agreed. Court of Appeals twice agreed. But defendant is now basically saying, but the police have to have a higher analysis here, much higher, to take a look at this stuff to see if they should have kind of known things that the judges themselves didn't notice, and defendant hasn't really even come up with this until the Supreme Court level. Now, the question about the Sixth Circuit precedent, about 2001, I was in an argument before this Court, and I made a little suggestion that maybe Sixth Circuit decisions are binding on this Court. That did not go over well at all. Sixth Circuit opinions are not binding. U.S. Supreme Court are. It's try to find the Michigan trial lawyers who are up on, the appellate lawyers who are up on Sixth Circuit case law. There aren't many. There aren't many judges that are up on it. And we're supposed to have the defense lawyers? Now, it makes it rather easy. That's the end of it. Defendant, incidentally, his brief did not address this. His reply brief said, well, the only thing it said in that one paragraph is, this was not ordered by the court. Well, it was. Anyways, there is another issue in here which is very, very troubling. 90 years ago in People v. Miller, this court unanimously said, when you're looking at a search and seizure issue on appeal, you may not look at what's going on, at what came out at the trial. However, when I take a look at this booklet here, and I look at the first paragraph, I see a lot of facts in it that came out exclusively at the trial. Exclusively. Now, what happened in this case was defendant filed a motion to suppress, and he based it exclusively on the preliminary examination transcript. He did not ask for an evidentiary hearing. I looked at it personally, and I thought, I happen to have found the LaBelle case. And based on the preliminary examination transcript, as so many
Counsel,
people...
good morning. I just have a question, and I understand where you're going, but I just want to understand from your argument, why couldn't the defendant just leave? After he's pulled over, what was requiring him to even stay there? Why couldn't he just leave?
Okay, I'm not 100% sure about that, but I'm pretty sure that when you're in the middle of a traffic stop, that the person may not leave. That is a question of officer safety. I'm not 100%. The officer definitely has the right to order him out of the car. Okay. We know that.
But this is a civil infraction. No one's being placed under arrest. It's not custodial.
Right.
So what I'm trying to understand here is, why am I here? Why can't he just leave?
Once it was done, he could have left, but for his being arrested. Yeah, certainly.
But he's arrested because he left his backpack in the car, correct?
That is correct. He abandoned it under LaBelle. That is correct.
He abandoned the backpack.
Yeah.
What should he have done differently here? He's ordered to get out of the car, correct?
Yes.
And he's ordered to leave the back. I'm just a little confused. If you have a traffic stop and you're ordered to do something by the police, how is that I can be ordered to do something and at the same time it's abandoned? I'm a little confused. Where's my freedom of choice in this situation?
There is absolutely nothing on the record at any point whatsoever that he was ordered to leave the backpack in the car. There is nothing that says that at all. He could have kept the backpack with him, and then when asked...
What would have happened? What do you think would have happened if he had exited the vehicle with the backpack? What do you think is on his mind in terms of, if I'm going to exit the vehicle and keep a backpack with me during a traffic stop, what do you think he's thinking if he does that? What do you think's on his mind?
Boy, that sure is speculative.
Sure, it's speculative, but with the current events of today, what do you think is a reasonable thing that he's thinking about?
Considering they're all white in this case, I'm not so sure that he's concerned about
Wait, what?
that other stuff.
I'm sorry. What did you just say?
The defendant is white, the police officer's white. They're all white, so we don't have a racial problem. If that's what you're talking about, the events that are occurring
Well, that's not what I was talking
okay.
about. I'm just trying to understand. You're the one that made that into an issue. I guess my question to you after you made that into an issue is, isn't anyone in a situation when, you know, you're pulled over by a police officer, you know, it's a little bit of a high-stress situation?
Of course.
Isn't anyone going to be in a circumstance or situation where, what do you do when you get pulled over? You put your hands on the wheel, right? Is it usually a smart idea to exit your vehicle carrying an object? Is that safe for the police? Is that safe
Not
for the
necessarily
passenger?
right away. Okay,
I
what do? I
Yes.
stop the car, I turn on the light, I get out my wallet, and I get out the proof of insurance and car registration. That's what I do. In this particular case, the defendant was holding it. He could have kept it in his hands at the time.
He could have kept the backpack in his hands?
As he left the car, yes, I don't see why not. The officer, there is no evidence that the officer told him to leave that. Instead, he left it, as in the facts of LaBelle, and whether LaBelle is correct or not, we still have good faith, because that is, or at least as of this moment, that is still the law in Michigan.
It sounds like you think it was incorrectly decided. Is that fair to say? Do you think
No.
LaBelle was incorrectly decided?
No,
You don't?
no, I do not.
So make sense of it for me, given Rodriguez and Gimeno. Make sense of how it was correctly decided.
Okay, Gimeno deals with when the officer, when...
Well, I know what they deal with. Just tell me why LaBelle, I know the cases, just tell me why LaBelle makes sense given those Supreme Court precedents, which
Because
obviously...
they don't have anything to do with this. They don't deal with a person setting it down, knowing that it's the car's going to be searched, and Gimeno specifically says you can search the packages in the car. He puts it down there. That's a matter of abandonment, as this court said, and there is someone on this right here who signed the order. And he was right.
Well, and there's someone else here who wrote a different opinion that was reversed and thought that Rodriguez applied. So that the someone here
correct.
argument kind of goes both ways. So I'm just trying to understand whether LaBelle was correctly decided. And it sounds like you think it is because it's
yeah.
distinguishable from the other. So
yeah.
why do you think no other jurisdiction has gone this direction?
I'm unaware of any cases that have specifically said that it's wrong. If you shepherdize it, you can't find anything that says that. And I'm unaware of any cases, certainly defendant has not come up with any cases that directly control under these facts. There is one case that is dead on point, and that's LaBelle. That's it. Yeah, when I found it, I was unbelievably shocked that I was able to find something so extraordinarily close. You normally don't find it that quickly. But basically, I have a three-part argument. The first part is, of course, good faith, assuming that you go outside it. The second part is, of course, the inventory search. And the third part is that LaBelle was correctly decided. Now, if, in fact, you look at the facts of the trial, and you're concerned about those, let's not forget a few little details. The prosecutor had absolutely no incentive to develop search and seizure issue at trial, very simply because search and seizure is 100% irrelevant at trial. Number two, it's not entirely fair to the judge to reverse him based on facts that no party bothered to present to him at the time. And number three, if you start saying, let's take a look at the trial facts, guess what the prosecutors will start doing? They'll start sneaking these facts into the trial. Well, we're not entirely sure that the judge made the correct record. We have more record, and we start putting stuff in, and you bet that will be prejudicial against the defendant, so that makes it bad. And if you take a look at the preliminary examination transcript alone, which is what Miller says, everything is fine. If you have a problem with this stuff, I recommend that the court remand for a full evidentiary hearing, something defendant has never requested.
Counsel, you keep saying that the defendant abandoned it by leaving it in the car, but what LaBelle held was that the driver consented to the search. Is that really what you mean? I'm just trying to understand if you're making a different argument than the one LaBelle stands for.
LaBelle stands for defendant left it in there knowing that the person had consented to searching the car.
Okay. So if I'm
Yes.
pulled over I'm riding in an Uber, and my Uber driver is pulled over, and because his plate's expired, and have I consented to have the police search my purse?
No.
Why not? I get out of the car. They tell me to get out of the car. Have I
You
consented
get out of
to
the car, you take the purse with you, you show them your identification that you're a Supreme Court justice, and you will be gone. There will be no
I'm told
problem.
I'm not allowed to tell them I'm a Supreme Court justice when I'm pulled over. That's unethical. My boss told me that.
Yeah, I remember Justice Taylor once giving a nice little story where he twice got pulled over on the same night, on the same stretch. And both times, well, this is a justice. The second time, the officer went up to him and said, Justice Taylor, what are we going to do with you?
That's when we had suppressed plates. I knew who he was.
That's how we knew. Yeah.
Yeah, and that was just my plate, too, suppressed.
All right, so you think I would get out with my purse
Yeah.
when the officer tells me to get out of the car? That's okay. And so you think the defendant here should have gotten out with his backpack, and by not getting out with his backpack, he understood that the driver's consent to search to the car extended to his personal bag.
That's right, and that's what it comes down to. Yes.
Isn't that what happened here? Didn't the driver get out with her purse?
Yeah, I think so. I'm not positive about that.
And
Didn't
she
the officer
consented to a
ask
search?
to search
Right.
the purse?
The officer has to search her, the male officer. Yeah, I know. And the reality is, it didn't matter that much to me because he didn't find anything. Did the officer have probable cause to believe before he searched the backpack that there was something in the backpack? I don't think so.
Well, I thought she consented to the search of the purse as well.
If she did, she did.
So here we have the defendant in the back seat,
No, in the front seat.
or the front and the passenger side, trying
Yes.
to observe what's going on.
I would assume so.
So leaves the backpack in there so he consent to a search knowing there's nothing on him,
Yeah,
I'm thinking, but that's my speculation. Let me get back to good faith
okay.
for a moment. Opposing counsel said that the record is sufficiently developed and was briefed in reply to you, and that, as I pointed out, the court did ask for anything else that could be pertinent. You did raise good faith.
Yes.
Do you agree that the record is sufficiently developed? Does it matter? Do we know? First of all, do we know whether the police officer was aware of the manual?
That is not part of the record. If, in fact, you think that is not good enough, I would suggest remanding for an evidentiary
Does it
hearing.
matter whether the police officer knew of the manual?
On the other hand, I am completely unaware of any case that specifically says, for good faith to apply, the officer must have actually known about this particular case. There are a lot of cases that came out after Arizona versus Gant came out in 2009, and none of them specifically said, oh yeah, we should ask if he actually knows about it. And it really comes down, let's not forget, it's an objective standard, not a subjective standard. People versus Arterberry, 1989, or is it 88, one or the other, unanimous opinion written by Justice Charles Levin basically said, oh yeah, there was a proper search here. They had probable cause to arrest based on this. Yeah, probably not a
You might
single
have answered
officer
my
knew about
question,
it.
but I didn't quite grasp the answer.
Okay, I'm
Opposing
sorry.
counsel thinks the record is sufficient, and if we go to good faith exception, he wins on the law. Do you believe the record is sufficient? And if so, I take it you assume you win on good faith exception to the law.
Oh yes, I win on the law.
Is the record sufficient?
I think it is. However, that's of course not the real question. The question is, do you think it is? So if you think it is, fine, then it's affirmed.
Mr. Schoenberg, what do we
Sure.
do with the fact that you didn't argue the good faith exception until your supplemental brief in this court?
Okay.
Why wasn't this something you argued to the courts below?
Because I happen to have a case called People versus LaBelle that was 100% absolutely dead on point. That's why. And it's not always a good thing to write a brief that happens to look like a treatise. Sometimes it's best to write on the short side. And it is, and I really, really doubt that
Well,
this...
those are two different things. Either, I mean, so I think I take your first answer to be, I can't have abandoned it, given that there's no reason to call it into question. So I shouldn't have been expected to make that argument until I got to this court.
That's a possibility, but abandonment is a rather interesting point. I really doubt that the Supreme Court, that this court, put in that third thing of, is there anything else, and then turn around and take it away from me and say, oh, by the way, it's abandoned, and we didn't really mean it. I'm
just asking what your argument is. I'm not asking
my
you to read my mind.
My argument
more
is...
concerned with what we think.
We'll get
Well,
to that later.
oh, yeah,
I just want to know
yeah.
what you think about whether
Number
it matters that it's
Number
not
one,
something.
LaBelle is correctly decided.
kinda
Number
talked
two,
about me.
if you overrule it, there's good faith. Number three, it was a good inventory search anyway. Those are the three arguments.
How's it an inventory search?
I'm sorry?
How's it an inventory search? They searched before the arrest.
It doesn't matter. If you take a look at the Bailey case out of Pennsylvania that I cited, which specifically said they could have done an inventory search, that's good enough. It's an independent source, therefore affirmed. If you look at the facts in the trial, the officer specifically testified, one, I searched it as an inventory search. Two, there's a policy requiring to look at it as an inventory search. And three, it was impounded.
But since that time, it's never been raised in the Court of Appeals or elsewise.
That is correct. And that's why when I took a good look at it once again, you see, once you granted the MOA, I had to reevaluate because I had always figured that LaBelle made it easy and that takes care of it. But I had to reevaluate. And when I saw that third line in there, the third question, I thought, okay, fine, I'll take a look at it. And there's no question that the car was properly stopped, and neither person, and it's downtown Jackson, and neither person had a license to drive the car. There's absolutely no question
So the
about
car's going
that.
to be impounded.
Yes,
It's essentially, when you say inventory search, it's inevitable discovery, or?
yes.
And if
And-
I'm riding in Justice Sar's car and it gets impounded because he doesn't have a license, I have to leave my purse there?
No. Of course not.
Okay.
If you choose to leave the purse, guess what? It happens to
Oh, this is
get
back to when you think
searched.
he left it there.
But I would never
Interesting.
consent to it.
Why would
I wouldn't consent to it either.
I like to
Is that
just
the lesson for today?
I like to just
Kids?
yeah, I just like to simplify things because I think the
Okay.
law kind of has to make sense.
That's
so,
a good thing.
Oh yeah, so let's just go back to the early argument, right? I mean, the thing is that at the end of the day, when you're looking at these cases and we're looking at kind of what the policy implication of this would be, you know, we're concerned about the officer's safety, right? We're concerned
Yes.
about the safety of the officer, and we're
Yes.
concerned about the safety of the occupants.
Yes.
So what you're saying is that if you get pulled over, you should just take everything out of the car with you. So if I get pulled over, do you think if we have some wonderful, wonderful officers here today, and if I was to ask them if they were doing a traffic stop, would they like the passenger of the car to take everything with them out of the car? Would they?
Keep in mind, I keep my CCW in my purse.
I mean,
It's in my
Yeah.
is this what
Well,
they
the
want?
reality is, of course, if you're stopped and you have a CCW, you have a gun, you have to say it right away.
Well, we're not.
Right
okay,
away.
That's a separate. We're not kind of on
Okay.
that. We're talking about the fact that I get stopped, right?
Yeah.
Is this what the officer wants me to do? Does he really want me to take all my things and stand and get out of the car with all of my things so he can't see my hands? He can't see what I'm doing. He wants me to take like a large item, like a backpack, out of the car with me. Otherwise, it's abandoned. Like this is
The
what the
law
officer's
does
going to
not
want.
require him to order him to keep it in. Now, looking at it from the defendant's perspective, he gets stopped. I strongly suggest that he not take the body out of the trunk. That would not be a good thing. No, I'm not suggesting that at all.
But
He
what-
should take the stuff he thinks is good. The problem is, of course, if he happens to have a gun under the seat. Oh, the officer will see the gun the moment he's taking it under the seat, and then that, of course, creates probable cause.
Well, the
Is it a different case if the defendant says, "May I take my backpack?" and the officer said, "No, leave it in the car."
Oh, yeah, we got a problem then.
Okay.
We got a problem then, definitely.
And just like you don't have to put your hands up in the air when you get stopped, you don't necessarily have to think, well, what's the officer going to want me to do, as Justice Bernstein is suggesting. You could have asked.
Yes, you could have asked. And this guy has said that he has a very, very lengthy criminal record, so he knew the drill.
So he should have, I'm just trying to understand what people are supposed to do. So when they get pulled over and the officer comes to the car, you have to ask the officer, your position would be that you have to ask the officer, "Officer, may I take all these items with me out of the car?"
No, I'm not saying that. In the first place, you sit in the car,
Right.
and if the officer never tells you to get out of the car, that's the end of it.
Right, but if he asks you to
If
exit
he
the vehicle.
essentially orders you out, and he has the right to do that, order
Right.
you out, you can take, a woman, it would shock me if the woman did not take her purse along.
Are you supposed to ask, or are you supposed to just do it?
You're supposed to do it.
Okay, so your
I
policy
don't think
is
you're
that
supposed to
you're
ask.
supposed to just take it with you out of the car.
Yeah. I rather doubt that he'll go into the trunk and take out the lug wrench.
But if the officer, if the person takes the item out of the car,
Yeah.
the officer can certainly ask to search it
Absolutely.
for officer safety.
For whatever reason, the officer has the right to ask. Of course, the officer has no right to search it unless he has probable cause.
Right.
And he has no right to do,
Or consent, right?
or consent, that's correct. Absent consent, he has no right to search absent probable cause, and he has no right to do the pat-down unless he has a reasonable suspicion that the person is armed.
The
And-
officer's not going to let the defendant or the passenger get out of the vehicle with a bag,
He's
holding
not.
a bag of material.
That's
If he's-
the position, yes. We're
That's-
supposed to get out with the bag. Yeah.
My
I mean,
position,
if you're worried about officer safety, you
Yeah.
have a right to do a pat-down search for weapons, but you think the officer then, if he's concerned for his safety, wouldn't be concerned if the person has a bag or a purse or something within arm's reach where they could conceal a weapon? You don't think the officer should be concerned about that at all?
if we use that analysis all the way through, that would mean every last single traffic stop, the police officer has the right to do a pat-down. And a lot of police actually think that, and that's not the law. You have the right to do a pat-down only if you have a reasonable suspicion that the person is armed. If you have no reasonable suspicion that the person is armed, the police officer has no right to touch that backpack if the person leaves the car.
I'm not suggesting they have a right to touch the backpack. I'm asking you if you think the officer is going to allow someone to get out of the vehicle while he's investigating the driver and having a conversation and allow them to be near a bag that could conceal weapons. Do you think that's standard police practice?
Well, could consider in any situation. The answer is yes. If the court says that they are to do that, yes, they will. Because otherwise, it's a bad search. And of course, that leaves the officer open to 1983 liability. Yes.
Thank you very much, counsel.
Thank you.
Are there any further questions? Are there any further questions of Mr. Ferrone?
Can I ask him just a question, just so you can clarify the record? Can you just help clarify this? What happened? Did he basically explain to me your position to this? Did he just basically walk away and say, "I abandoned this backpack in the vehicle so it could be searched"?
No, he never left the scene. The officer asked him to get out of the car. He got out of the car. He left the backpack where he was sitting. And he never leaves the area. The record says he was 15 feet away from the police when the police start to search the backpack. I could elaborate on that more, but I actually think the questions I've heard indicate that you already understand my position is to expect people to grab objects under these circumstances is dangerous for the police and the citizen. This is where a danger, and I also agree with you, Justice Bernstein, there's no racial aspect to this. We had a shooting in Eaton County some years ago. It was a white officer, white student, so this would apply to everyone. But also, the law puts the burden on the state to prove abandonment, consent, etc. It doesn't, and the law is very clear in stating Florida v. Royer we cite in the brief, but even as recently in Birchfield v. North Dakota, that cooperation with the police at the scene does not equal consent to anything.
Thank you, Counsel.
Okay, thank you.
Thank you very much. Well, thank you again, everyone, for being here. We're very honored to have been here in Muskegon today, and we will look forward to speaking with as many students as we can and the members of the bench and the bar here in Muskegon at the reception to be held shortly. Thank you again. We stand adjourned.